I'm John, for anybody that doesn't know me. John Ross. Started the Ross and Schulmeyer firm about 15 years ago here in town with my partner, Lisa Schulmeyer, with basically one idea, and that was we wanted to address people's big concerns, which was stay independent, not be a burden on their family, and not go broke. And that's what we did. We started out, we're now the largest elder law firm in the state of Texas or the state of Arkansas. So apparently there was a demand for this kind of information. And I'll tell you, a lot of this started back about 15 years ago as I was doing mostly wills for people. That was really why I went to law school, was I was interested in doing wills and trusts and stuff like that. But what I was seeing was people were coming in and they were very concerned about their home. In fact, up until relatively recently, for the vast majority of people, the bulk of their net worth was their home. Some of that is switching now as you see people have a lot of money in IRAs and 401ks and stuff, as companies got away from the old good old-fashioned pensions and switched everybody to 401ks. So sometimes you're seeing a switch there, but still, for the vast majority of Americans, the home is their biggest asset and obviously something that they're concerned about protecting. The good thing here is that the home is actually a very, very protected asset for most people. There's a lot of benefits to you being in possession of your own home. So what's your name? Barbara. Okay, I'm picking on you the whole time, all right?
Okay.
All right. So, if I own a home, and let's just say that I reached over and yanked Barbara's chair out from under her, right? And she falls and she gets hurt, and she, of course, is going to file suit against me, and we got 121 witnesses to this little action here. So there's going to be plenty of people that are going to say, yep, we saw John yank Barbara's chair out from under her, he hurt her, and she's going to win this lawsuit, and she's going to get a judgment against me. You can't take my home. It's a protected asset. Now, I could even turn around, file bankruptcy, and dismiss that judgment altogether. So I never have to pay you, and I'm still going to be in my home. My home's a pretty protected asset. So it's generally protected from creditors. You go out and decide you don't want to pay your credit card bills anymore. Well, yeah, you rack up a debt there, but they can't take your home away from you. It's protected. On top of that, there's all kinds of little tax benefits, right? I mean, if once you reach a certain age, your property tax gets frozen and it doesn't go up anymore. So there's some age-based exemptions that you get. Of course, if you're disabled military veteran, things like that, there's other tax benefits. So a lot of tax benefits to owning the home. And so it's a pretty protected asset. And so yet, people are very concerned. A lot of that comes from a lot of rumors out there. And probably the biggest one, and the reason people will come to me and say dumb things like, I need to get my house out of my name, and I'll tell you why that's a dumb idea in a second. But the reason most people is because they have heard somewhere along the line, particularly if they need some sort of long-term care, right? If they have to go to a nursing home or something like that, that they're going to take their house. All right, so let's be very clear, nursing homes are not in the real estate business. They do not take houses, right? It's rent, right? If you walked down the hall and over to the little booth here at the Holiday Inn, they will rent you a room tonight for probably $150. And tomorrow morning, I think they give you a free breakfast. You could jump in the car with Deanne from the Ponderosa out there and drive out to to DeKalb, and you could stay at the Ponderosa nursing home tonight. And it's going to cost you probably about $150. You'll get dinner tonight, breakfast in the morning, and lunch tomorrow afternoon before they want another $150. So 3 meals. That's a better deal than where you're at right now, right? But as long as you pay $150 night after night, you can stay at any one of them as long as you want. So it's not that they're in the business of taking homes, all right? They don't do that. That's just not their thing. But most people can't afford $150 night after night, because you start rounding that out and you're looking at $5,000-$6,000 a month. Most people can't afford that, which means most people are going to end up either right off the bat or at some other time later down the road trying to qualify for Medicaid, because Medicaid's the only government benefit program that pays for nursing home care. Medicare doesn't. Right? If you go to the hospital and you spend at least three midnights in the hospital, go directly from the hospital to the nursing home, well, Medicare will pay 100% of the first 20 days. They call that rehab. It might pay up to another 80 days, depending on your insurance and your supplement and things like that. But at an absolute maximum, Medicare is not going to pay any more than 100 days. After that, you're either going to pay $150 a night or qualify for Medicaid. And so this is where this all comes from. But people don't know anything about Medicaid. They don't know, for example, that in order to qualify for Medicaid, you can have a home, including all land the home is connected to, as long as the total value is worth less than $560,000 and qualify for Medicaid. It's a big house. It's a little house on a whole big chunk of land, right? Either way, as long as the house, and if I walk out of the front door of the house, every piece of dirt I can walk on without crossing somebody else's dirt, right? So the house and all the connecting dirt, long as the total value is less than $560,000. So not only is your house a protected asset for you in case you are texting and driving and hurt somebody in a car wreck or don't pay your bills or so it's protected from creditors, and it's also, you get tax benefits from having the house, and then on top of that, you can qualify for Medicaid and still have the house. So where does all of this come from? Well, it all comes from a little law that really kicked in about 2005 called the Medicaid Estate Recovery Program, MERP. If you've been receiving Medicaid benefits during your lifetime, the state would like to get paid back when you die. So Medicaid is a loan, just like Discover Card or anything else. It's a creditor. And at your death, Medicaid wants to get paid back, and they have a claim against your estate. But here's the deal. That word estate means something very specific in legal terms, because when you die, some things are part of your estate and some are not. Let me give you an example. Me and Barbara, we're going to go down to the bank, right? We're going to go over to Regions or whatever, and we're going to open us up a joint checking account in your name and my name. So the account's owned as John Ross and Barbara. And if we would have paid any attention when we signed up for this account, buried in all that paperwork, because that's one thing they're good at, is paperwork. And they're going to have all this paperwork, and we're going to have to initial this and sign here. And in all of that, it says that we own this account as joint tenant with right of survivorship. Virtually every joint bank account out there will read the same way. So we open up this account, I pull out my wallet, and I deposit $100 of my own money. And then I ask the bank, I say, hey, can I borrow a piece of paper? And they say, sure. And they hand me a piece of paper, and I write out a will. And I say, hey, I'm John. I'm making out my last will and testament. And I have just put $100 into bank account number 12345 that I've got here at Regions in my name and Barbara's name. And when I die, the most important thing in the whole wide world is that Danny over there gets my $100. You're welcome. And I get the will signed, I get it witnessed by a couple of the bank people, have one of them come over and notarize it, and I have created a perfectly valid, fully enforceable will, and I'm so happy I did all of this. I'll walk out the front steps, not paying a bit of attention, walk right in front of a bus and die. So who's getting my $100? Barbara. Barbara gets my $100. Now, the will says it goes to Danny. I'm sorry, man. My will only controls the property that passes through my estate. There's that word again, estate. That didn't. This $100 went to the surviving joint owner on the account. Okay? That's what they call a non-probate transfer or a non-testamentary transfer. It went to her according to the contract. One of us dies, whoever outlives the other, they get the $100. I had a lady yesterday, well, not a lady, my client's the surviving spouse, but there were 2 kids from the deceased spouse, and these 2 kids are really, really unhappy. And they're really, really unhappy because Dad's will said, I want, one kid to get $100,000, I want the other kid to get $100,000, but all of the accounts were in husband and wife's name. Joint tenant, right of survivorship, which means he died, everything went to the spouse, outside of the estate. So there is no $100,000 for that will to give. Just like Danny not getting my $100, right? But the reason all of this is important, the reason I keep pressing on this is because Medicaid has a claim against your estate. If an asset doesn't pass through the estate, there's nothing for Medicaid to claim against. So the key then is keeping the asset out of the estate. Now we're back to talking about the home, right? So I can have a home, I get all my tax benefits, I stay in control of my own assets, and I can qualify for Medicaid and still keep the house. All of that stuff is great. But if that house is sitting there in my name and I die, then it becomes an estate asset. And if it becomes an estate asset, Medicaid gonna snatch it. And it doesn't take long. We just got a Medicaid claim for somebody. Mom was in the nursing home for about 3 years, and the Medicaid claim that we received was $175,000. Because when you qualify for Medicaid, not only are they paying the nursing home bill, but they're also typically covering prescription drug costs and Medicare co-payments and lots of other bills that may be hidden out there. And so they can rack up a bill really fast. So, in 3 years, they're coming up on $200,000 worth of debt, and they'd like to get paid. But if there's nothing in the estate, no big deal. If the house is part of the estate, they're going to want to take it. Now, there are some exceptions to this. Medicaid will not try to make the claim if there's a surviving spouse, right? So if husband is in the nursing home and he's on Medicaid, been on Medicaid for years, his death, there's a $500,000 owed to the state, but he is survived by a spouse, the claim goes away and never comes back. Period. Don't rely on this. It's very easy to get a little overly focused on the sick spouse, right? You got one that's in the nursing home, so they're obviously not doing great. And you get to thinking, yeah, that's the nursing home spouse. They're going to die first. Yeah, not always. In fact, not even most of the time. You start talking about something like Alzheimer's disease, and from the time you're diagnosed with Alzheimer's till the time that disease kills you, and it will, it's 100% terminal, 100% of the time, but that's going to take about 10 to 15 years. The life expectancy of the spouse of somebody with Alzheimer's is 3. Really, I didn't make that up. 3 to 5. So it's so hard being married to somebody with Alzheimer's that it kills the caregiver. And so you have this tendency, you think, oh, well, Dad, he's got Alzheimer's, but if he goes to the nursing home, that's all right, he'll qualify for Medicaid, and Mom will be at home, and when he dies, the Medicaid claim will go away because Mom will still be there living in the house, except that from all the stress of dealing with him, she has a heart attack and dies, and then he dies, and now there's no spouse. So I wouldn't count on that. There are a few other little exceptions. For example, if your beneficiary is a disabled person. So if you leave your house to your child, but your child has been declared disabled by Social Security, Medicaid won't claim against that person. If your beneficiaries are very poor, if they're less than, I think, 300% of the federal poverty level, they generally won't collect. So there's a few things. Also, if the total value of your estate is less than $10,000, they generally won't try to claim. So if you've got a very, very small house, or if it sat there empty for so long that it just kind of collapsed down around itself, and I've seen that happen as well. But if it's less than $10,000, they won't collect. But again, you don't really want to rely on this. It's so much easier to just keep it out of your estate. If you keep it out of your estate, they can't touch it. So how do you do it? Well, the one most people think of is give it away, right? If I just give it to my kids or something before I die, then I won't have it. This is a terrible idea. First of all, when it comes to Medicaid, if you have given away an asset, Medicaid will not pay for you if that gift happened within the last 5 years. They say for every roughly $5,000 that you give away, that's 1 month they're not going to pay for you if that gift occurred within the last 5 years, right? So you take your $100,000 house, you put it in your kids' names, and 3 years later, you need Medicaid. Well, take $100,000, divide that by 5,000, and that's how many months they're not going to pay for you. What's that, 200? That's a lot of months, right? So just giving it away. Now, you could give it away, and if you did give it all away and you got beyond the 5 years, hey, you're golden. Unless the person you gave it to dies, and it goes to their spouse who never liked you in the first place, because it's their house now. And when they kick you out, there won't be anything you can do about it. And I've had that happen. I got a lady that pays rent to live in her home because of that. Put it in her son's name, son died, went to son's kid, but son's kid was only a year old, so it went to son's kid's mama. And she said, get out. It's my house. Kid could get divorced, in which case their spouse probably going to want half your house. They could file bankruptcy, in which case your house will be sold to pay off your child's creditors. In fact, we've got 3 or 4 Medicaid applications right now where the clients that have hired us to obtain Medicaid are the parents trying to get the Medicaid for their child who's in the nursing home. And when I say child, I'm talking 40, 50. I mean, y'all gonna, if you have any luck, y'all gonna get older, right? We've got 2 clients right now at 108. And one of them, they live with their son. He's 90. You keep getting older, you know what happens to your kids? They get older. As my mother likes to say, she's too young to have a kid my age, right? And so, if you're having concerns at 65 about your potential health problems, well, when you're 85, and that kid you had when you were 20 is now 65, and they're having these same concerns. So all of that to say, giving the assets away doesn't protect it. But what we can do is we can keep it out of the estate. There's several different ways to do that. And some of this is going to start getting into state line issues. The problem with doing a class like this, where I could, if I had a really good pitching arm, could go outside and throw a rock into Arkansas, and if I had a really good pitching arm, I could throw one to Louisiana. It gets a little bit complicated. So I'll try to break it down by state. In Texas, we have 2 different ways to do it. One of them is a deed. And this is a deed. Let's say I'm going to the nursing home. I want Barbara to get my house. Here's what I'm going to do. I'm going to deed my house to Barbara. But in this deed, I'm going to say, you know what? I'm deeding it to Barbara, but anytime I want to, I can sell it and keep all the money. It's my house, so I can live in it, I can use it, I can do with it whatever I want, and anytime I want, I can sell this place and keep all the money. But if I don't, I've deeded it to Barbara, right? What have I given her? As far as value, right? Have I given her anything of value right now? No, right? Because at any time I could sell it and keep all the money. So I have not given her anything. So for Medicaid purposes, I haven't given anything away, right? So no 5 years deal, right? I haven't given anything away. But the very second I die, I have lost the ability to sell it, right? I cannot go back and sell it now. I'm dead, which means the home is Barbara's. I have deeded it to Barbara, retained the right to sell it, live in it, all of that. I die, bam, it's yours. It did not go through my estate, and since it didn't go through my estate, Medicaid can't touch it. Bam. That was created by a professor of law at Texas Tech University, a guy named Jerry Bayer. He actually came to Texas Tech after I was there, but he's a pretty neat guy. He actually designed the legislation in Texas that allowed you to create a trust for your pets, which is kind of weird. But anyway, he wrote a paper on this type of deed, and in the paper he said, imagine that Lady Bird Johnson was going to a nursing home and wanted to protect her house. And ever since he wrote that paper, everybody has called this stupid thing a Lady Bird deed. Lady Bird Johnson did not actually do this. It was just an example written in a law school paper. But everybody calls this a Lady Bird deed. So it's a pretty good little deal. It's very easy. These have been around for a long time. They're relatively easy, but it's got a couple of little problems to it, right? If I deed it to Barbara, I retain the right to live in it, and I could sell it and keep all the money, right? But what if at some point in time I decide I just don't like Barbara anymore? How do I change this? Do I sell it to myself? Or, I don't want to sell it because I'm living in it, right? But I don't want her to get it when I die anymore because we've fallen out. I want Danny to get it now. But this gets very difficult. So it's not easily changeable. So that's kind of a downside. The other problem is if I have a mortgage on this property, the bank is going to freak out on this deed. They're not going to want me deeding the underlying title to somebody, and I can argue with them all day that, look, it's still mine, and I can. No, they're not having it. And the problem is, in a mortgage like that, they contain something called a due on sale clause. And what this means is, if you have the mortgage and you deed out the underlying title ownership, then the whole mortgage comes due in one payment. Bam. Although this Lady Bird deed, it works very well, but you generally can't do it with on mortgaged property, and it's not easily changeable. Texas legislators actually came up then with a secondary solution. They passed this law in 2015, and this created what they call a transfer on death deed. And all this is a deed that says, here's who gets it when I die. That's it. It's just a deed that says, I am naming, like you would name a beneficiary on a life insurance policy, right? It's your life insurance policy. You can name a beneficiary on it. Now you can name a beneficiary on a house. So it's a transfer on death deed. Good thing is, we're not actually changing the underlying title. So if I've got a mortgage on a property, I can still do a transfer on death deed and it won't trigger that due on sale clause. So we're good there. Also, the statute says if I decide I don't like Barbara, all I've got to do is file another transfer on death deed. So if I file a second one and say, nope, never mind, it's going to Danny, well, that's what's happening. So it's easily amendable. But like everything the legislators do, regardless of who you voted for yesterday, they will screw it up in some way, shape, or form. Doesn't matter who's in power, none of that matters. They're going to mess it up because they really don't know what they're doing, right? They're there to make laws, but they don't know the real details of the underlying laws that they're making laws about. So they messed this up. They did two things that I really don't like about this. One, they put in there that you cannot do a transfer on death deed using a power of attorney. Right? So Dad just never would get around to doing anything. He did have some powers of attorney, but he just wouldn't get around to doing anything else. And now he's had a stroke, he's mentally incapable of handling any affairs. He's at the nursing home. The kids are looking to protect assets. Maybe one of them has a power of attorney, but they cannot use this option. Because you cannot sign a transfer on death deed on behalf of somebody else with a power of attorney. That's one problem. The other problem, and this is the one I really don't like, is in the law, they said, if you do a transfer on death deed, and I do one and it's going to Barbara, and I was in the nursing home, and when I die, Barbara's going to get the house, and Medicaid will not be able to make a claim against the house. It says that in the statute. But then they put a comma. If they'd have put a period right there, it would have been fine. But they didn't. They put a comma. And after the comma, they wrote, but it will be available for any other creditors I might have had for at least 2 years following my death. Right? So if I had been in the nursing home on Medicaid and did a lot of shopping on Amazon with my Discover card and didn't pay that bill, right? So now I've died. I owe both the state of Texas and Discover. Well, the house is protected from Medicaid. Good. But not protected from Discover. Now, here's the real problem with that, right? So I've died. Barbara, you've gotten the house with this transfer on death deed, but you don't want my house. You got your house. You're just going to sell mine and take the money and go have fun. So you're going to try to sell the house. And Danny over there, he says, well, I like John's house. Mine burned to the ground. I've been trying to build another one, and I've had enough of that headache, so I'm just going to buy John's house. This is all true. I know him. And so he says, hey, Barbara, I would like to buy that house. But he's going to look at that deed, and it's going to say, oh, wait a second, that's a transfer on death deed. If I buy this house today, any time in the next 2 years, somebody John owed some money to could pop up and take that house, which means the house is basically unsellable because Danny's a smart guy. He's not going to buy my house knowing that a creditor could pop up anytime in the next 2 years. So I really don't like that about it either. So both of those have some pros and cons there. On the Arkansas side, we don't have either of these options. Arkansas does have what's called a beneficiary deed. And this is just a deed that says, here's who gets my stuff when I die, much like the transfer on death deed in Texas. Except when Arkansas wrote their little laws, they said, you can do a beneficiary deed. And when you die, it'll go automatically to whoever you named as a beneficiary. Automatically, doesn't pass through probate, easy breezy, but if you were on Medicaid, we get to take it. Not exactly word for word, but pretty much what it says. So a beneficiary deed on the Arkansas side doesn't necessarily protect the house. In fact, it doesn't from a Medicaid claim. So you got to get a little bit more creative over there on the Arkansas side. One option that we have used successfully several times, in fact, a couple of hundred, again, I can't give anything away, right? Not anything that has value. But what if I just give Barbara a little piece of my house? Let's just say I gave her 1% of my house. So I do a deed and I say, John, I'm John, I own 100% of this house, and I'm going to transfer to Barbara a 1% interest in the house. So now the house has two owners. John owns 99%, Barbara owns 1%. And you and I are going to own this house as joint tenant with right of survivorship. I just turned the house into that bank account, right? One of us dies, it automatically belongs to the surviving joint owner. Your 1% becomes 100% because you're the only other owner. The very second I take my last breath. So I die, it's yours. You could do this with a power of attorney, so you're good there. You can't do it on mortgage property, but you can do it with a power of attorney, so you're good there. These are a little weird, so you won't see these very often, and so they can cause some issues with title companies. Where the title company goes, what in the world? Right? So you're trying to sell mom's house, and the title company's looking at it going, I've never seen somebody deed a 1% interest with right of survivors. That's the craziest. And they don't know the context. Once it's explained to them, they're usually fine with it. But all of these are options because, again, we're not impacting the 5-year deal. We're not doing any of that. So these are all things that are generally going to be ways that you could save the house. And you could do this even if you were already on Medicaid. So this is not pre-planning stuff. This is stuff that you could do in a crisis. So if you're sitting back and you're worried about, well, if I ever go to the nursing home, they're going to take my house. That's just false, right? The only reason you would lose the house is failure to have planned for this, even if the planning happened at the time of the crisis. Now, all of these do, and I got a few minutes left, so I want to cover one other thing because there's one drawback to all of these. I mentioned earlier, like with Alzheimer's, you're talking a 10 to 15 year life expectancy. And that life expectancy is actually starting to get bigger as the medicines and the care and things get better. But it doesn't necessarily mean the disease is getting better. It just means the person's not dying as fast from it. And so with things like Alzheimer's or Parkinson's, stroke at a young age, things like that, you can look at some very long stays in a long-term care situation, right? So, I've done this ladybird deed or transfer on death deed or whatever. So it's my house. I'm still in control of it. And when I die, it's going to go to Barbara. The problem is, if I spend 4 or 5 years before I die in a nursing home, what are we doing with the house? Is it just sitting there? Because I'll have clients and they call and they say, well, John, can we sell the house? Nope. Because it's my house. And if you take my house, which doesn't count against me, and you sell it, now we have cash. And the cash certainly counts against me for something like Medicaid. So the house ends up basically being unsellable. And if it's a couple of weeks in a nursing home, maybe even 6 months in a nursing home, that's not too big a deal. If it's 4 years in a nursing home, it's gonna take somewhere around the 6 to 12 month range before the first crackhead breaks into my empty house and steals all the copper out of the walls. Or the air conditioner off the back porch. Or whatever it is that they do. You can't, on top of all of that, generally if I'm in a nursing home, all of my household income is going to the nursing home each month, right? So if you're a single person, you're on Medicaid, you get $60 if you live on the Texas side. You get $40 if you live on the Arkansas side. You get $30 if you're in Louisiana. But even if I'm in Texas, so I get the big money, right? I got my $60. Well, $60 is not going to pay for the property taxes, the homeowner's insurance, and frankly, if you don't at least keep some basic utilities on, you're going to have a problem there, right? So, again, I'll have the kids, and nobody's done anything in advance. The kids are going, you're telling me we can't sell it, but we also Mom can't have any money to pay for the utilities or the taxes. I'm like, yes, that's what I'm telling you. I need you to consider this an investment. You're going to pay for all of that as long as Mom's alive. And then when she dies, you're going to get a house that hopefully will have some copper and an air conditioner. So all of these have that problem. So the one thing is, if you are pre-planning, again, I don't recommend giving assets away, but for example, take my parents. I created a trust for my parents, a trust that was designed so that they could stay in control of their own assets, that it would still be theirs for tax purposes, and that they could make all the decisions related to their trust. So they could buy, they could sell, they could do things like that. But nothing in the trust will count towards their eligibility for something like Medicaid benefits. Now, the house, which doesn't count against them anyway, but I did include the house in that trust. And why? Because if they go to the nursing home, I ain't messing around with that empty house. I'm selling it. If it's in the trust, nothing in the trust counts. If that's the house, doesn't count. If that's the sale proceeds from the house, doesn't count. Now, this is still subject to the 5-year rule. So doing that for parents that are retiring at 65 is no big deal, especially now when they're 72, right? Because I'm 7 years past on a 5-year look back. So we're all good there. But that's a pre-planning tool. It's a much more powerful tool. It's still theirs. Homestead exemption's still the same. All of that's still the same. They can still sell it. They can be in charge of it. Not subject to my problems. So if I end up in the nursing home or get divorced or file bankruptcy or whatever it is that I got going on, none of that's affecting their assets, but does give me a bit more freedom. And trust assets pass outside of probate. No estate. So once again, we escape the Medicaid estate recovery. So there's ways you can do it if you're planning in advance. There's ways you can do it even if you didn't. The one thing you shouldn't do, though, is get it out of your name. That's the bad one. That's actually exposing your assets to other problems. So I'm not saying don't do anything at all, but just understand that you don't have to worry about protecting the house. There are ways it can be protected, even in a crisis, even if you don't do anything at all. So I got 2 minutes. I'll take 1 or 2 questions if anybody has any. Anything?
If you have a
Yes, sir.
trust in the state of Florida, do you need to change it so it's in the state of Texas?
Good question. Your question is, if you have a trust that was created in the state of Florida, do you need to change it if you've moved to Texas? No and maybe. Something that's validly created in one state is valid in every other state. This is the full faith and credit clause in the Constitution. This is why you can go to Vegas and get married, and you're still married when you come back to Texas, right? Because it's valid in that one state, which means it's valid in every state. You laughing at my jokes? So the trust is valid. The fact that you created a valid trust under Florida law, but maybe you have moved, doesn't change the fact that it's still a valid Florida trust there. There are occasionally some odd differences between the states. And I like to use Louisiana as an example because they're so weird. The first time I ever dealt with something in Louisiana, I was looking at a Louisiana will, and the will was from a husband, and it said, "I leave my wife a usufruct." That's exactly what I said. What in the world is a usufruct? U-S-F-R-U-C-T, usufruct. It's a life estate, that's all it is. It's just, it's the right to live in the home and use it and do it. But I'd never heard that word my whole life. I had to go grab Black's Law Dictionary from law school, knock the dust off of it, and dig through there to the U's until I found out what a usufruct was. So you can end up with some very strange differences based on some wording or things like that. So anytime you do jump state lines, not a bad idea to have something reviewed. It probably doesn't need to be changed, but not a bad idea to have it looked at depending on the states. I will say Florida and Texas are very similar. In fact, the only 2 states in the United States that you can use a ladybird deed are Texas and Florida, of all things. So the states are very similar, so probably no big deals, but yeah. Anything else? Let me go here and then I'll come back to you. Go ahead. So your question is, you've got a home, great, which I said earlier is a non-countable asset, but you also have a couple of rental properties. I'll answer your question with a story, as I do with just about everything, as you'll find. So we had a lady in Jefferson. She lived in her home, which was about $50,000 house. She lived off of $900 a month in Social Security, plus the $300 a month in rent that she got from the house across the street from her. That was a little rent house, and it was only worth about $20,000. She also had about 10 grand in savings. So her estate was a house, a 1988 Mercury Grand Marquis, 10 grand in the bank, and this rent house that paid $300 a month in rent. She had a stroke, she was going to the nursing home. The house doesn't count against her. The car doesn't count against her. Of the $10,000, the family used 8 of that to prepay for her funeral, which doesn't count against her. So that left her with a house, a car, a funeral, and $2,000, which is the bare minimum to qualify for Medicaid and a rent house. Can't qualify with that rent house. Anybody interested in buying a $20,000 rent house in Jefferson with renters paying $300 a month? No. So we can't sell the asset to get the care, but we can't qualify for Medicaid because of it. That's a real pickle. We were able to sell it, took about 4 months, got less than what it was worth, and all of the proceeds from the sale basically went to the nursing home to pay the back bill on that deal. So when you have other assets, whether it's retirement accounts, whether it's CDs at the bank, whether it's timberland, whether it's rental properties, those often now take additional planning, because those are not things that you can have and still qualify for Medicaid. So those are going to need to be shielded in some way. So yeah, good question. You're thinking the right direction. And then you had one, and that'll be it.
If you're dealing with a parent with dementia already, still at home, we're taking care of her in her house. Her house is not worth much of anything, probably needs to be knocked down when she's gone. She does have 5 acres of land that she's living on. Can you do not the deed transfer, but the first one that you talked about in Texas? Can you, on her death, she still is in, we have power of attorney, but we are not guardians of her. She still is in charge of her, but what can we do can we protect anything since she's already dealing with dementia?
Yeah, so your question is, mom's already got dementia, still at home, but she's already got dementia, has a house, got some acreage there. And your question is, could you do something like the Lady Bird deed or the transfer on death deed or something like that? Yes, the short answer is yes. You mentioned you have power of attorney. Assuming the power of attorney gives you the power to do that sort of thing, then you could do a Lady Bird deed with a power of attorney. If mom still retains some competency, she could probably do the transfer on death deed or the Lady Bird deed, either one. So yeah, you've got some options there. And when it comes to estate planning, the mental capacity it takes to do estate planning is actually relatively low. This gets a lot of people, they'll come to me and they'll say, John, mom did a will, cut me out, left everything to my no good brother, and I want to fight it. And I say, okay, why do you want to fight it? Well, he did that will in 2016, but in 2015, he was diagnosed with Alzheimer's. So, in order to do estate planning, generally you have to know who your people are. You have to know the nature of your estate, so the objects of your bounty, your stuff. And you have to be able to retain that information in your mind long enough to perform the act that you're doing, right? So at the time that Dad drew up that will, did he know who his people were, what assets he had, and who he wanted it to go to, and did he know that from the time he started doing that to the time he finished doing it, which is a relatively short period of time, right? And if so, then he was legally competent for that matter. So mom may be able to do it depending on her level of capacity. And if not, that's where the power of attorney comes in that gives y'all the ability. The fact that she's already incapacitated, not an issue. All right, listen, I appreciate it. That's the time frame. I like to try to get y'all out of here on time. Y'all are welcome to hang around if you want some of the door prizes and stuff. So anyway, appreciate it.